My name is Nathan Laurie. If you are new here, we talk about the law and the facts. If you're about that life, don't forget to like this video, share this video, and subscribe to the channel. Let's hit on the Twitter wars, because all this is the Twitter wars. We were talking about the Twitter wars earlier. So let's get to the Twitter wars. I know Kurt says he hates Twitter, but I love it for content because a lot of my best ideas come from Twitter, to be honest with you. All right, so I got to explain to people what happened and how we got to where we are at. So you'll be able to hear all these things too. Thank God. So Cernovich, who I do like. Cernovich is good, and he's generally good with his facts. No doubt about it. No shade to Cernovich. He's good with his facts, but he's wrong on the Alex Jones thing. Now, I don't know why these ultra right-wing people are just trying to, carry water for Alex Jones, but it's happening. So Cernovich writes, Judge and Alex Jones keeps lying by saying he didn't provide discovery, right? Judge, in one case, demanded Jones turn over Google Analytics data, which is true. We heard that last night. Google banned him, no way to access it. But we know this is not true, right? Because we read the documents last night with Natalie Lawyer Check. When you read the documents, Alex Jones and his company had the information. They had the documents. They told the court they had the information and had the documents.
Also, have these people never heard of a third-party subpoena?
Yes.
Just because, okay, Google has banned you. Okay, fine. How about a subpoena? That's how you do that in court process. If you don't have it yourself, subpoena them.
And see, that's what a lot of people don't understand about discovery. It's not just we can just ask you for anything. We can only ask you for stuff that you can have, that you have care, control, and you have access to. So if you don't have access to it, and I say, well, give me the president's emails, and you can easily say, well, I actually don't have any access to it. And if you show reasonable that you don't have access to it, then they're not going to force you to turn over President Biden's emails because you don't have access to it. So the same thing here is that it wasn't that they didn't have access to it. They had already told the court on the other side they have it. And the issue came from the court documents with them trying to give it. They said, oh, we emailed it to you. They said, well, we got the email. We didn't get it. We did this. Oh, we didn't get it. And eventually they just stopped giving it. And then at the end said, okay, well, we're not going to give it at all. So that was the issue with the Google Analytics. And we read that last night on Natalie Lawyer's Chicks. That's exactly what happened. Back to the beef. So Cernovich says this, right? So then he says, judge pretending he could and then not turning it over violated the court order. Again, if you just read this, you don't know that the fact that they said they had it. You don't know the fact that they said they tried to email it to them. You don't know that they said they had the actual documents. You don't know that then they had somebody after they said they had the documents to try to give it over. Then all of a sudden they said they didn't have access to it and couldn't turn it over. Like you don't know any of that. That's what this person's putting out. So,
and if you read the judge's sanction order with respect to the entry of default, if you read the default judgment, they say in the decision that Alex Jones's side agreed to give over discovery and then just didn't. Yeah, they didn't say, at least according to the judge, it wasn't we don't have it. It was we'll give it to you and then just didn't, which is not an option. You can't do that. You can't just say we'll do it and then just not. If you don't have it, you can say we don't have it. You can do that, but you can't just stop participating.
And people have to understand too. Then you get some people saying, well, he gave depositions, right? Alex Jones gave depositions. And you're like, he gave discovery. He did discovery.
He did some discovery.
Yes.
He among other things, though, failed to provide a corporate designee because, again, reading the actual court decisions, when they did send a corporate designee, the corporate designee didn't know anything. So that doesn't really count. You can't send a corporate designee and then the corporate designee be like, I don't know. Because the whole point is to know. And you can't do that. So yeah, there were discovery problems.
Yes. So just to be clear, if you're in court and they say give us A, B, C, and D, and you give them A, B, and don't give them C, then what can you do, right? Then the court can say, well, you have to give us C. And you say, no, I don't want to give you C. Discovery isn't something that you can just pick and choose what you turn over. No. You have to turn over everything. Now, again, these are from the court documents.
There are rules.
Yeah.
So there are ways to contest subpoenas. There are ways to contest requests for production, right?
Yes.
So you get a subpoena, you get a request for production, you get a demand for documents. You don't want to participate. Okay, there are ways to do that. Normally, one of the ways to do that is a motion to quash, right? We don't want to do it. We don't think we should have to because of these reasons. We think this is invalid. We think it's overbroad. We think whatever. And then you go have a fight about it. And then that's a legal way to determine what you do or do not have to discover. So just because they send you a demand doesn't mean that you have to say yes. You can say no because here are reasons. And if those reasons are legally valid, then you don't have to turn it over. But you can't just not turn them over. There's a process. You have to go through the process. This is also one of the things where people say, for example, Alex Jones was denied due process. I'm like, no, he wasn't. There is a process. He got the process that was due. There are rules to this thing. If you don't follow the rules, that's not you not getting due process. That's you refusing to participate in your own due process. Those are two different propositions.
Yes.
So this is a little bit, Now,
someone just put up, I think I lost it, but that Barnes disagrees. Well, the thing is that Barnes says you're wrong. Well, I'm not saying anything. I'm just reporting what the court documents said. Yeah. So if Barnes is saying the court documents are wrong, then he should prove that. But I do also want to mention, and again, Barnes is cool. I don't have any problem with Barnes. But Barnes is highly, highly biased in this scenario. Just to be clear, let me show you why Barnes. This is from the Alex Jones trial that just occurred. So again, this is why Barnes is heavily biased when it comes to this. So I'll play you my reasons why Barnes is heavily biased.
So that's why the judge is rigging the court proceeding to make sure that the script, this is literally a script gets told in a certain way for future audiences.
That man's name is Robert Barnes?
Yes.
Okay. That's InfoWars?
Yes.
He was hosting your show.
Hosted the show.
Yes.
Well, you were on the show for part of the 29th, right?
He was on the show that day too.
I believe so.
Okay. And Mr. Barnes, he's a frequent anchor on InfoWars?
Frequent anchor.
He's been a frequent guest for about 6 years or so.
He's also represented you in this case?
Represented him in court, 6 years, good friend.
Okay. Yeah, the representative thing is kind of where you can stop the analysis. Because as a lawyer, you have a duty to zealously represent your client. It's one of your fundamental obligations as a lawyer to be competent, to maintain your client's secret, to not screw with the client's money, and to zealously represent your client. So he is deliberately, by ethics, not supposed to be neutral. He's supposed to be a zealous advocate. That's his job. So, I mean, I don't know what more you can say beyond that than to say, okay, he has represented Alex Jones in the past. He is still associated with the company. He appears to still have some representative role to some degree. Even if he didn't, he's not going to completely undermine a former client's, because that would be completely unethical. You wouldn't, as an attorney, be like, well, they were my client in the past, and now let me go disparage them. It's just like, that's not what you do. You have obligations. So I have complete respect for Robert Barnes. I believe he is a fantastic attorney. He's a fantastic litigator.
Oh, yeah.
I believe Robert Barnes is going to do his ethical obligation. His ethical obligation is to zealously represent his client. So he's not supposed to be neutral. So saying that he's biased isn't insulting him. It's saying he's doing his job. He's doing his job of supposed to represent his client. That's his job.
Just like Elaine Bredethoff, right?
Right.
She's just doing her job, right? So for those, so now I understand. A lot of people will say, well, we believe and we believe. Hey, listen, that's fine. But just understand, you're
Robert Barnes, and to be completely fair, just because he's biased doesn't necessarily
mean he's
wrong.
Doesn't mean he's wrong.
He doesn't mean he's wrong. Just because he's an advocate doesn't mean he's wrong.
Doesn't mean he's wrong.
Because attorneys who are very passionate, passionate is exactly the wrong word. Let me try again. Attorneys who are very zealous, that's the right word. Attorneys who are very zealous often are correct in court.
That's correct.
Because that's how court decisions get made. So just because he's zealous doesn't mean he's wrong. But it is a note that he's supposed to be representing one side. So he's not attempting to be neutral, even if he is ultimately correct.
This is a very technical matter in law. And whenever you have a technical legal matter, the problem is that since a lot of people don't understand it, there's a lot of, I think, a lot of people who live in that realm of, since the public in general doesn't understand it, we can say whatever we want about it. Oh, just say he did turn over Google Analytics, and I bet you millions of people will believe that. You're like, I don't, well, I read the court documents, because how many people are going to be like me, you, and Natalie, and go and actually pull the court documents and say, well, they said they had it. They said they were, matter of fact, they said they were trying to turn it over and couldn't turn it over, right? Mm-hmm. That's a totally different mindset than hearing, oh my God, oh my God, oh my God. After Mike says this, I played this clip and I put here, this post is blatant misinformation for the purpose of making Alex Jones seem innocent. The discovery request was for how many videos Alex Jones and company released concerning Sandy Hook. They refused to turn over that information, which was their reasonable discovery request. Do not trust me. Here's the judge saying it. So then I put the clip of the judge literally saying it during the trial. Here it is.
That you have tried to imply to the jury that we know how many videos about Sandy Hook were released by your clients, when we don't, because they refused to respond to discovery. So I do not want you to do that again. And I don't want you to argue with me about it. That is the rule of this case. That's it. They didn't respond. We don't know. So don't couch it in that language. Your Honor. I'm still talking. I'm not really being asked to do anything except tell you to follow the rules, which I feel like I've done many times already. We've had multiple conversations about how I know you know what the rules are, and you know what the rules are, but you've chosen not to follow them on occasion. And I'm asking you again, follow the rules. We are not going to take up sanctions in the middle of this trial. So if somebody wants to file a motion for sanctions, we'll take it up at the conclusion of the trial.
So we hear directly from the judge in the case what was not given, right? How many, because, and think about how important that information is to a defamation case. Because one of the elements in defamation is how many video, well, was it published to a third party? So if they released 10 videos versus releasing 100 videos, that is extremely necessary for us to understand in a defamation proceeding, right? Right? So if now I'm asking you how many did you, and you don't tell me how many you released, then it kind of just goes to shit, right? Because it's like, how can I prove my case when you are not turning over relevant discovery information? So that's essentially what we're seeing here.
Okay, Nate, I'll ask you this. Mm-hmm. Just show me what you're relying on that the court said indicates Alex's non-compliance.
Can you pull up the docs, Kurt?
Let me see if I can find them. Hold on.
Okay.
Give me a second.
Well, you read them on stream too. Kurt read them on stream.
Paraphrase and that he didn't. Just paraphrase it because I think we'll agree on that. Or
okay.
Well, for example, they said paraphrase, and the court said that when they designated a corporate designee to speak for the corporation, that the corporate designee was unable to answer any questions, that they were unprepared to answer questions, and so failed to serve the function as a corporate designee.
Okay.
That was one example.
Mm-hmm. Okay. And I'll grant you that. Default verdict, foreclosed from pleading, that's the appropriate sanction for that default, even if we accept that that default might have been failure to fully participate.
That's only one example,
well,
right? If just off that one example, I don't think it's enough.
I want the examples, because the straw manning is this. Okay. Barnes didn't say Connecticut's lying, Texas is lying, wherever the other one is lying. What Barnes said was that they had asked for stuff. This is where the debate started. Cernovich said the judge asked for documents Jones couldn't provide because Google wiped clean analytics, wiped clean the videos, as did YouTube, deleted the videos that were there. The argument is, at the time, take it for what it's worth, believe it or don't, even if it's not true, to go from that to say verdict by default is an abuse of the system.
Well, but the thing is that you left out the whole part before we got there. And so the part that you left out, like you started with turn it over, delete it, and then you can't turn it over. But you left out the whole part that we talked about yesterday, myself, Uncivil, and Natalie the Lawyer Chick. When we read the documents, it literally said Alex Jones and company said they had this material to turn over. they actually even said they tried to turn it over. They tried to email it. And when they checked the emails, they were like, well, we didn't get the emails. They said, oh, it must have been our mistake. Let's try to email it to you again. So this is not saying, so I think the mistake here is that you're saying that he couldn't have access to the information, which may be true, but in the court documents and in their representations, they said they already had the information and was trying to give it to the plaintiffs. That's the difference in what we're talking about.
Well, because there's a number of things. Now, what information are you talking about there?
The same thing you're just talking about, the Google Analytics and all that stuff. Okay. They said they had that information.
So this is the question. I'll go one step further and grant what you're saying, that he had the information of Google Analytics videos published on Sandy Hook and did not turn it over.
They tried to turn it over. They attempted to turn it over, and whatever happened.
So I'll grant you the benefit of the doubt. That's true. Foreclosed from pleading, does that default, in as much as it is a default, preclude the plaintiffs from making their case when all of those videos were published at one point, public at one point? Apparently they didn't see them at the time, but set that aside. Does that lead to the remedy of a default verdict, failure to foreclose from pleading, foreclosure from pleading your innocence, foreclosure from pleading your absence to inflict emotional distress? Is that the appropriate remedy? And if it is, well, I think we'll just disagree on that. And if it's not, how did that happen in Connecticut, Texas, if the court system and the system is not, in fact, out to get Alex Jones?
All right.
And go for it.
So you've asked, there's two questions involved in that, and I'll answer to both of them. So the first one, can you just, what was the first one again, just so I can be clear? I don't want to.
Take for granted, because we saw the judge say it. Jones's default was failing to provide a list of the videos published on Sandy Hook. Let's just say he did not provide that list. Okay, so to that first question, if we're just saying, okay, for the Google Analytics or providing the list, is that one thing enough to provide a default? I don't think it is. But I haven't read any of those defaults that said, because you didn't turn over this single piece of evidence, that we're defaulting. Each one of the ones, even the ones that we read last night, had multiple discovery violations in documents, in phone numbers, in text messages, just like we saw in the, hold on, just let me finish, just like we saw in the Texas case yesterday. So one of the interesting people were saying that there was only one thing, he didn't turn over the videos. But yesterday we saw in display that they also didn't turn over text messages, which were part of the discovery request. And when Jones found out, when the lawyer said, well, we got them by accident because your lawyer made a mistake and turned them over to us. And remember, we asked you, did you mention anything with Sandy Hook? Now, every lawyer in this call knows that in discovery requests for those text messages were supposed to be turned over if they were relevant to Sandy Hook, if he was talking about Sandy Hook, and he did. And that's why yesterday they got caught out there, because they mistakenly turned it over. And when the other guy got him, he said, your lawyer didn't even claim privilege because the lawyers were trapped in it. So if we're talking about now if you want to just say this one example is why it's defaulted, then you're right, totally. They shouldn't have gotten default for one example. But if you're saying that if you take all the discovery violations together and it doesn't lead to a default, I think that's where maybe we have the disconnect, because I'm looking at it, but I'm looking at the whole pie, not just the crumbs on the table. Well, what you're looking at is a mess without parsing it out. Yesterday, what were the dates of what were the alleged text messages that were on the phone that he had that he did not disclose? Do you know what they were?
No, I know what the,
okay,
I do not know exactly what was in the text messages, but I do know. Hold on.
Do you know what the dates were?
I will say this. Let me tell you exactly what I do know about the text messages. I know that they were for the past 2 years, because that's what was elicited at trial. I know that those text messages that Alex Jones was asked specifically whether he ever texted about Sandy Hook, he said no. They gave him a warning about perjury, that obviously he testified under oath about this. So he had a perjury warning. And then he came in, and then they showed how he was directly talking about Sandy Hook in those text messages. So that's what occurred yesterday.
What was the date where he might have been talking potentially with his attorneys about Sandy Hook? Do you know the dates?
They didn't say he was talking about this to his attorneys. They just said they were text messages.
Okay.
They didn't say.
Do we know the dates? Do you know
they didn't say.
Do we know if the text messages in which he's talking about Sandy Hook, allegedly in violation of a court order, was after the default? Because last 2 years includes a 9-month period where he had already been found in default. So are we going to argue now that subsequent text messages about Sandy Hook that might have post-dated the verdict by default would be evidence of default.
Okay, okay. So what you've just done is just said, I assume that they happen to be after the default, and I'm assuming now. I'm saying what I'm saying is I don't know.
I think information that came out after the default could further justify the default. Sure.
Yes.
Because if you find further evidence. Yeah. After the default that he's been in non-compliance, then that would be further justification.
Yeah,
yes, he was in default.
Who's hypothesizing?
Viva's right though. Viva's right.
Ask me something. They said we have emails from the last 2 years. That includes a 9-month period after whatever it was on his phone. 9 months after the verdict default had already been rendered, and you guys don't even know what's on the phone, relying on a lawyer who is now admitting as evidence privileged information that was accidentally leaked to him or sent to him by counsel, and you haven't stopped for a second to think maybe some of those messages, it might be evidence, Kurt, that he did not comply. Maybe a text message that says,
I mean, as to the privilege issue, it doesn't appear to be privileged because it appears that they didn't object on the basis of privilege.
So hold on.
Unless I'm mistaken, because I mean, the lawyer yesterday said that there was no objection on the basis of privilege.
Because what you've done is you've thrown out. You said they were obviously privileged. If they were privileged, his lawyer could have easily objected and said these were privileged, blah, blah, and we would have never even heard about them. But they did not do that. Right? They did not do that. Look, so now you're claiming privilege from the case with the lawyers. No, but that's what you just said. You said it was privileged. You just said it was privileged.
The lawyer himself, when he introduced it, said, I believe he said it was privileged. If not, he alluded to the fact.
He played a clip.
No, he said he basically asked about whether it was privileged or not, and they
did not say. They did not say it was privileged. I'll play the clip. I'll play the clip if there's confusion.
No. I know the clip. He said it was. He knew it was sent to him by accident.
Right. He asked them.
He knew it potentially. Who did he ask? Did he ask Alex Jones?
He asked his attorney. Yeah, he asked his lawyer. Is this privilege? And they didn't respond. And he said, okay, well then we can use them.
Who can waive privilege for a client?
That's why you ask his lawyer. Is this privilege? Hold on. It's unethical for the lawyer to talk to. It's unethical for the plaintiff's lawyer to talk to Alex Jones. Are you trying to say that plaintiff's lawyer is supposed to talk to Alex Jones? Because that is unethical at all. That in the United States, you cannot talk to Alex Jones.
Only the client. Only the client can waive privilege, but that presumes that they are privileged. So you have to get to the underlying question about whether they're privileged or not.
Kurt, that's the end. Only the client can waive privilege. The lawyer did not say that the attorney waived privilege. The lawyer said after having accidentally received this from the lawyer, they did not get a response within 10 days. First of all, did you see the email notification or the request to confirm that any privilege was being waived from the lawyers?
No, but he made a representation.
No. Answer this question.
No, I didn't see that.
Did you see the request from the lawyers to confirm that Alex Jones waived any privilege over this, accidentally sent information to them? Did you see that?
No, I did
not. As to waive privilege? No. As to whether they are privileged?
Kurt, let him finish his point. Let him finish his point. Go ahead,
You did not see the request.
No, I absolutely did not see the request. I did not see that. Go ahead.
We know that they did not get a response. So they did not get confirmation that Jones had waived privilege.
That's correct.
They sit on this for 12 days during the trial to spring it, allegedly 2 days after any privilege would have waived it. I don't think that's an accurate understanding of the law. And now that's good enough. So your understanding, after admitting that only the client can waive privilege, these attorneys got no confirmation that Alex Jones waived privilege, and they took this information to court.
All right. So now let me explain, because I wanted to make sure I heard you out. That is a bastardization of this privilege argument. And I understand, and I just want to say this. The reason why this is a bastardization of the privilege argument is that they sent the plaintiff these documents. And the plaintiff then asked, when they saw them, is this privileged? So now they asked the lawyers. Now, first rule of thumb, the plaintiff's lawyers cannot talk to Alex Jones. That is unethical. There's no way in the United States. Just let me finish my point. So what did they do? They then contacted Alex Jones' attorneys and said, hey, you sent this to us. This is crazy. Is this privilege? Hold on. They sent it to him. I don't know what they said, but they sent it to him, right? Here it is. This is what you sent us. Now, it is the responsibility at that time of notification, because that's the ethical rule, is that you've been notified you sent something that wasn't supposed to be sent. Is it privileged? At that point, they're supposed to write back, yes, this is privilege, blah, 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 blah. And you do a privilege log. You let them know, hey, this is not supposed to be there, blah, 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 blah. They did not do that. So then the other side says, okay, well, if this was privileged, then the other side would have told us it was privileged. But since they're saying this, they're not saying it's not privileged, they're not saying anything, they just sent it to us, then obviously it must not be privileged because they haven't made any showing of privilege. But what you're now saying or suggesting is that the plaintiff is supposed to automatically know that something's privileged when they've been sent, it seems like discovery documents from the other side, and the other side is not claiming privilege at all. No, well, so what I'm saying is that I think what you're doing is you're trying to make a privilege problem, but you have to assert the privilege, and they didn't assert the privilege. Now, to your last point, because you made this point a couple of times, I want to make sure it's debunked properly. The point you keep in, did they ask Alex Jones? Did they ask Alex Jones? The technical answer is yes.
Never asked
they asked his attorneys, and his attorneys didn't say it was privileged. So the rule of thumb is, if you don't claim the privilege, it's not privilege.
There's nothing better. There's nothing better than asking a question that nobody asked. I did not ask, did they ask Alex Jones? Because I know that a lawyer cannot contact a represented client. What I asked is, first of all, none of us know in what measure they said, hey, did you mean to send this to us? It seems to contain privileged information. What's clear is that they know that it did. Otherwise, first of all, otherwise they wouldn't have asked in the first place, even if they did ask. Set that aside.
Yeah, that's wrong. That's wrong. That's absolutely wrong. Anytime they say, I don't know. I've gotten things from people that wasn't supposed to get, and I always send it back. Hey, did you send this to me by mistake? Is this privilege or is this? And they'll tell you, oh yeah, we sent this to you, but oh no, we meant to send it to you or whatever. So just saying that because it looks like it's privileged to me, that's the reason why I asked. That's why I asked.
Not because it looks like it's privileged, because it looks like they knew that it was privileged. So set that aside.
It looks like they knew that it was privileged, and they ask, "Is this privileged?" And they say nothing.
Now,
so it's not privileged.
I did not ask if they asked Alex Jones directly. I asked, do we even know if they asked if the client is waiving privilege? So we don't know what they asked.
Good question.
They said, and by the way, I've been a lawyer, for everybody who knows, for 15 years now. And someone will get at something and say, we don't know if their email, did you mean to send this to us? If it was as innocuous as that. And by the way, an ethical attorney will make sure that someone has waived privilege, even if they think the clawback provision means what you think it means, and I'm not sure that it does. If they think that it contained privileged information and they know that only the client can waive it, and they send some email, hey, did you mean to send this to us? Oh, 10 days later, no answer. He waived privilege. I'd like to see it. Setting all that aside, even if it does contain incriminating information, I'll go back to even giving you the benefit of the doubt. He had been in default already for 9 months. What this proves, other than the fact that they are willing to take information that's accidentally sent to them that seemingly has very little to do with this trial because he's already been found in default, that says something to me. But we've already gotten, so that's the bottom line on that. If they're going to say he's waived privilege, they know only the client can, I would like to see what assurances they made to ensure that Alex Jones had waived privilege to his counsel before they took that to court 12 days into the trial. But what does that information even prove in that phone, Nate? What information was in that phone? You're on mute.
Well, you gave us first. You gave us a whole bunch that I think Kurt wants to respond to because he's been waiting patiently. Go ahead, Kurt.
Well, this whole discussion presupposes the information is privileged because yes, only the client can waive privilege, but that presupposes it is privileged in the first place. And so it seems perfectly proper that an attorney gets information that appears to have not been disclosed purposefully. It appears to be an inadvertent disclosure. So if you get an inadvertent disclosure, there are ethics rules involving that, as you well know. One of the things that you want to do is you want to consult the other side. Like, was this a purposeful disclosure? Is it privileged? You know, is there a problem here? So that you make sure that, you know, that you're using it properly. So this kind of inquiry is a standard inquiry. Asking whether or not there's a privilege problem isn't saying that I think it is privileged or not. I'm asking you because I want to make sure that I'm able to use this information properly in keeping with my ethical canons. If the process under the relevant rules is you have 10 days to respond and then don't respond after my bona fide inquiry, if that's the procedural rule, then that's the procedural rule. Then you have waived your privilege by failure to respond. If that's the process, that's the due process that you're due, then that's the due process you're due. So as to what the information, as to what these text messages disclose or not, I can't say. To what value they might have at trial, they can serve as impeachment to the extent, if any, that Alex Jones is saying certain things are not true. If the text messages show the opposite of that, it's valid as impeachment. It's like, well, Alex Jones, you said this on the stand, but you also said this in a text message. Therefore, there's a contradiction, therefore impeachment. So it would be valid as a method to attack the credibility of the witness under an impeachment theory. So I hope that's answered to some of your questions.
And I just want to make sure I just put this at the end. The plaintiff's lawyers have no obligation to determine if Alex Jones himself waived the privilege. That is ridiculous. The only thing they can do is ask his attorneys, right? Because they can't talk to Alex. They can only ask, did he waive the privilege or not? And they didn't respond. So they can only do what legally they can do. If they respond and say, yes, this is obviously privileged, then we got a different issue. So privileges have to be asserted in this issue. It's just not this whole, we're not going to use it because it's not privileged. That's why you ask. And that's why when you don't respond and the law says, well, then, hey, they got 10 days to respond. If they didn't respond, it's obviously not privileged because they should have asserted it. Then that problem isn't with the plaintiff's attorneys. I think the problem that we really have is with Alex Jones' attorneys doing two things. Number one, they should have told him this happened. Right? There's no way they should have had him on the stand. He didn't know that they got this information. And then second, I think, is that he should have made it very clear that he was going to keep the privilege. And since the attorneys didn't do that, maybe he's got a malpractice claim, but the plaintiff's attorneys have no issue with using the information they got because of the way it happened.
I think it's well true that the client that a party can waive things by not doing things. That is the nature of the default in the first place. As to whether or not that's an appropriate remedy, given the facts that are present, is obviously an issue that's debatable. But the idea that you can reach a default judgment by failing to do things is not a concept unknown to law. Whether or not that's true here is the specific problem. So the failure to do things can result in waiver. It can result in waiver of personal jurisdiction. It can waive venue. It can waive privilege issues. It can waive all kinds of things. So if his lawyers are not doing certain things, then yes, certain issues can be waived. Then Alex Jones's only remedy at that point would be say, well, you should have invoked that. You didn't inform me. That's a malpractice problem, but it's not a problem as to the underlying waiver.
Let me just read this quickly. This is Rubia, who practices in Austin, Texas. Actually practiced before this judge. She's 29 years experience. She's practiced in 43 states. She says in Texas, she knows the Texas. This is the person I go to Texas. In Texas, you don't even assert privilege. You withhold it if inadvertent disclosure, you get notice, and then you get 10 days, which happened here, to respond to demanding return of the documents. Assert it if privilege log request. And that's kind of what happened here, and they didn't do it. So I think the issues with his attorneys, but the information I don't think is the issue.
No, well, I'm not convinced the issue is the information itself either. Setting aside the fact that the accusations that he withheld information that they had requested, to the extent that any of it occurred after, there could be evidence that he withheld it before in the 9-month period afterwards. But lumping 2 years together when the default verdict came about a year ago, without identifying which text messages might have actually evidenced the default before it occurred, not after, because after is a totally different story, are questions to be asked. I didn't think it was a Perry Mason moment like
I didn't think it was a Perry Mason moment either. I didn't think much of it. Yeah, I didn't think much of it.
Yeah, I think they're making more of it than it was. Yeah.
Well, no, they certainly are, especially since we don't actually know. I mean, we don't know what was in there. In that phone, except the alleged defaults, which were not providing a list of videos of Sandy Hook and some financial information as to the gross revenue of InfoWars, all of which, by the way, was still known to the plaintiffs themselves. The whole underlying issue
does not excuse you on discovery.
That doesn't excuse you.
It's not a question of excusing you. It's a question of whether or not the alleged default to provide certain requested information in discovery prejudices the plaintiff's ability to make its claim.
Yes.
To warrant a verdict default. In this case, by the way, there was no denying how much InfoWars was making. In fact, the judge refused to allow Jones to even say that it was $165 million a year to get into the details of it. The alleged defaults, even if we grant that they are there, and I'm prepared to concede it, not providing a list of certain videos, not providing certain financial information, even if he did in fact do it. Yeah. In any realm that it leads to a verdict default without having to make your evidence in front of a jury, a preclusion of asserting your innocence, absence of ill intent, even at the damages stage. I mean, that is a kangaroo court. I mean, I don't care. You may think, yeah, sometimes you can have such a serious default, which typically consists of destroying evidence or concealing evidence that would allow the plaintiff to make their case, which is not the case here. So even granting everything you're saying is true, all of the defaults are true as formulated by the judge, nothing in it can warrant what is happening right now.
Well, I will give you partial points on the fact that it seems to not only be because of the confines of the particular case, but because of Alex Jones's conduct cross cases. To the extent that that's proper or not, I think that you have a reasonable case. So it doesn't seem to be that the judge is saying necessarily that it's because of the misconduct within the confines of each of these particular cases, but rather his conduct cross cases and cross jurisdictions that shows, at least in the judge's view, an overall contempt for the process of cases resulting out of the Sandy Hook stuff. Now, so there's an argument there that maybe the judge is improperly considering things happening in Connecticut courts. Maybe that's an argument.
That's something I'm going to be, because you got to be intellectually honest with this stuff.
I try to be.
I do think of course you guys are definitely both being intellectually honest. But what I'm saying is even myself, and like when I read the Texas default, that was one of my first problems with it. It's like my biggest issue with the Texas default is that I think the judge did rely heavily on what happened in other courts in other jurisdictions. He did this in Connecticut. He did this, and I think it's inappropriate to rely. And it was like, oh well, I don't think any other sanctions are going to help because it didn't help in these other places. I think that would be where I would say is inappropriate. But the judge went through painstakingly, to try to make it lawful. So I don't really know how it's going to be on appeal. But if you're asking me the Texas default, do I think it's vulnerable to attack? Yes, because I do think the argument of, well, you did the same thing in Connecticut, so I'm going to default you before we get to that. I think that may have been a little bit, but that's specifically to that one. The rest of them, each one is different. And the Connecticut one, I think is a little stronger than the Texas one. There's two other ones that are out there that I think are really strong because again, we're talking about giving over all the stuff that they said they didn't give over would be necessary for them to prosecute the case. If you don't give them over, then you get your pleadings get struck and you're going to default.
Scott Lewis says, I do wish Barnes was here because he's intimately familiar with the case and Viva only has superficial information. I definitely don't have Barnes level information.
Yeah, Barnes is
tune in Sunday night. And also the lawyer, Rubia, says they do not have financial. They scrapped public information. Appellate court agreed.
That's true. Appellate court agree with that. Yeah.
I'll agree. And I will not get into the politics of the potential appellate court. Scrapping financial data does not have an impact on plaintiffs proving their case. It might have an impact on defendants' ability to pay, but to say they did not disclose their financial information, that will not affect any judgment that you're going to render on the merits of the case. And to purport that failure to disclose financial data in whatever detail they were asking, because first of all, they did communicate some financial information. I don't know if it was all, but I'll take for granted it wasn't. To say they didn't show how much they're worth, therefore we can't prove our claim on the IIED and defamation, that's hogwash. That might affect the ability to pay. But if the ability to pay is going to affect the quantum of the judgment, well, then you might have something above law here. So even that, default on showing your financials does not deprive plaintiffs in any meaningful sense of their ability to prove their claim on IIED and defamation.
Financials goes to show motive, potentially.
Yeah, financials
they knew that they were raking it in.
I'll tell you.
Yeah, well, but you want to show the jury. You want to show the jury the exact numbers. It's they made this.
Hold on. Let me give you a case where it's a defamation case where you did have that, and that's what's her name? Cardi B. Cardi B's case was a case in which they did, and then Tasha K had to turn over her financials to prove the motives intended, because again you had the mens rea component. So they showed the motives and showed why, and then in that case it was proven that she not only said it, but she said it for profit. So in some cases defamation, and plus don't forget you also have an IIED claim to also. But now again that's I think a technical thing with the court. But when you're talking about discovery, you turn all that stuff over and then argue the merits of whether it should come in or not after that point. Just like we saw in the Depp Heard trial. They turned over all that stuff and then argued in their motion to eliminate, hey, this should be kept out because it's irrelevant. You don't hide the information and say, I don't believe it's relevant, because that's what gets you the discovery violations.
First of all, Rubia says, Kurt is right, shows motive for specific videos. First of all agreed. They're running banner ads on these videos. It's not denied information that they're making money off of it. Second of all, it shows motive. So if you fail to produce that information, you draw a negative inference of fact on that issue. You don't foreclose from pleading and render a verdict by default because they wouldn't prove the motive to financially profit when that is obvious.
Look, I think here's what I will agree with you on. I will agree with you that any of these things in isolation is insufficient to reach a default judgment, because I agree with you. The kind of things that you're looking for in isolation that would get you a default judgment are the kind of things that you were alluding to for earlier, like destruction of evidence, right? That kind of thing where it's like this really egregious conduct, you know, the purposeful destruction, manipulation, altering of evidence, this bad faith context, spoliation. That's the kind of thing that would on isolation. And we don't have, I don't think, any of those things. I think we agree. So the only question is whether or not these individual things, which on their own are insufficient, are in the aggregate, whether in respect to the one particular case or potentially across the scope of all cases, potentially in the scope of multiple jurisdictions, whether or not those in some sort of aggregate are sufficient. And I think there is a valid legal argument to be made that there's a problem. Now, I will only take note here that on the appellate level, then you're looking at abuse of discretion analysis as to whether or not the judge abused the discretion in affording the particular remedy. And abuse of discretion analysis is pretty hard. Of course, I'm not saying it's impossible. I'm not saying he can't win it. But if you're saying that the remedy for these things are not in accumulation enough, I mean, that's literally a judgment call.
Yeah.
And so, I mean, I'm not going to say that you're like fundamentally wrong that, okay, it's a judgment call. Are they cumulatively enough or not? That's a judgment call.
Okay, Rubia says not under Texas law, Viva. And Rubia, I mean, I'm not purporting to be an expert, period. I've read the statute and I see that foreclosed from pleading is further down in the potential sanctions. In the aggregate, some of these, and remember where this debate started, I have to go because people are pressuring me.
Yeah, sure. Go ahead.
Hold on, this debate started with Nate saying that Cernovich was wrong. I won't say that on the fact that Cernovich said the judge lied. They asked for documents that Jones could not produce. Nate said Cernovich is lying. Here's the video that shows her saying, I asked for not lying. Cernovich is wrong.
Just specifically, because what I'm saying is Cernovich didn't give you the whole information because he said this is the only thing, and I'm like, no, it's a whole bunch of stuff. He didn't say the only
thing. I don't know if he said the only thing.
Here it is.
Cernovich said the judge asked for documents that Jones couldn't provide because Google wiped it clean. We all know that that's actually true. Whether or not there was other stuff. You played the video of the judge saying, I asked for a list of the Sandy Hook videos, and you did not provide it. You refused to comply with discovery. I then said to that, the next day, the judge walked it back quite a bit because it went from refusal to comply with, did not fully participate. And that's where the debate took off. And the debate had nothing to do with what's available online and where you can get the clips. The debate had to do with whether or not the judge walked back her categorical of the day before as Nate's evidence to contradict Cernovich's, where there's probably an aspect, there is something true in all of it. The judge did say that. Cernovich was right because they asked for documents or lists that Jones couldn't provide because YouTube wiped the videos clean. Apparently they didn't. You know, if I live stream only on YouTube and don't keep backups, I won't have access to those videos either. I won't know. The judge, in my view, walked it back the next day when she said did not fully participate to justify the verdict by default. And then the question is whether or not you think these are appropriate sanctions based on your disdain for Jones, or whether or not you think that they're excessive sanctions, notwithstanding your disdain for Jones. And how do we proceed from here?
Just a quick question. I still don't understand how the judge walked anything back. The judge said, here's a specific violation. Go ahead.
She said he refused to comply with discovery. Correct. On Wednesday or Tuesday. And on Wednesday, then referred to it as did not fully participate. If you don't find those things to be very different in scale, then we'll just agree to disagree.
Viva. Not complying with not complying with discovery is not fully complying with discovery, right? It's not. No, it's like saying you didn't pay your home for your home. You say, well, I paid $10, and it's like it's worth $100,000. Well, it's under you paid something. That's you know,
Nate,
if that's the parse that you want to say, the judge statement. Let me just be here. When the judge said he didn't fully comply with discovery,
Didn't fully participate in discovery.
Well, he didn't comply with discovery. That is true. And if he says he didn't fully participate in discovery, that's also true with the first statement, right? You can't choose and pick and choose what you choose to comply with discovery. Either you fully comply or you don't comply. Now, I understand you're trying to make that parse between, well, she said he didn't comply, then she said he didn't fully comply. There is no distinction between the two. Either you comply or you didn't comply. That's it. Right? It's like,
and I will disagree, because refusal to comply implies that he did not already turn over millions of emails, read and unread, some financial information, and then to say he did not fully participate, well, that could mean he didn't produce 1 document, 2 documents, a list of videos foreclosed from pleading. There's a distinction. If we don't agree on that, at least we know where we disagree.
I honestly think Jones should have gone to trial. He should have taken care of the discovery, gone to trial, because I honestly think he could win. His chances of winning are 50-50. And the reason why I think he could win is the Rachel Maddow defense. I think you can't get past the Rachel Maddow defense, because it's like, who believes Jones? Because don't forget, the key question for Alex Jones would be, who believed him? And that's what got Rachel Maddow off, and that's what got Tucker Carlson. And we all say this guy's a lunatic, cringe, nobody believes what he says.
But especially,
and now you're saying that you get defamation.
You get into the public figure debate, which defense proved. These are public figures. They made it their business to write books, figures, and it had to have been made with actual malice. And the judge made the best defense for Alex. I know you believe what you said. Well, there goes actual malice in terms of proving defamation against public figures.
No, that's incorrect, because you have.
I know it could be totally reckless.
Reckless disregard is true.
She said, "I know you believe it."
But even if you believe it.
Well, there's the threshold as to whether or not it's a total. Okay.
No, because let's say I believe it, and then you get absolute evidence that it's fake, and you recklessly disregard it because you say, I just don't believe that. That's recklessly disregarding the truth.
I thought that was a constructive discussion. And there was even, I think Viva has a valid point, because it's literally a judgment call, right? It's literally a judgment call about the whole default thing, right? We all agree that the court has inherent authorities. We all agree that there's a series of sanctions the court can impose. We all agree that default is the worst sanction you can get. It's not much worse than you lose as terms of sanctions go. So it's the most severe sanction. And so then it literally is a judgment call. It's, do you think that Alex Jones did enough things within the confines of this case? And if not, do you think we should go beyond the confines of that case to other cases in Texas and or other cases in other jurisdictions, including Connecticut, and whether or not we should combine those things, or even can legally, whether or not we can, even assuming we can, whether or not we should. And even if we can and should, you could still come to the position that it's all not enough in the aggregate to reach this most severe sanction. It's literally a judgment call at that point. And then it's just back to where I noted. It's like, as a matter of law, it's an abuse of discretion analysis. So if you're going to try to challenge this on appeal, you're going to have to show the judge abused their discretion in some or all of those things. And it's, it's as Andrew Branca likes to say, appeals are for losers. So, you're having a rough go of it. But, he does have a point that these are, the most severe sanctions that are possible. So they should be viewed skeptically, I think is fair.
Yeah.